Hello. Good evening, my viewers. This is Princess Ifem Show. Once again, we're here today to bring to you a great topic on immigration law. Ndị be anyị kenekwa m unu daalụ nọ onye unu na n'onu ya taa bụ nwa unu nwaanyị bụ Princess Ifem Enwerem. Anyị abịakwana ọzọ na program a na-akpọ Princess Ifem Show. Onye mụ na ya nọkwa unu ga-anụkwa olu ya n'ihi na o ji ọkpụrụkpụ okwu ọ ga-ekwu maka ya maka immigration law in the UK tata. Mana because of ndị nwere nsogbu abụrụ ọsọsọ ndị Igbo anyị ga-eji bekee wee kwuo okwu so that ndị ọbụla ga-enweta uru this topic bara. Daalụnụ. Now, good evening, my viewers. This is Princess Ifem Show. Today with me, I have wonderful person who is going to be discussing the current law on EU regulations. As you all know, the if you're not legalized in this country is a big problem. So this is why I have it in my heart to actually bring somebody like him to give us some highlights on how we can do to be stable in this country. God bless you all. Today I have with me Mr. Norbert Ohanugo. Mr. Norbert, you're welcome, sir.
Thank you very much. Thank you.
Nice to have you again.
Thank you.
A lot of people have been asking, where are you? Why haven't you come up again? And today I'm sure you guys are there seated firmly. Better get your pen and paper as he's talking. Just write it down. Once again, this is not an advice center. We're just giving you an information. And after the show, if you feel like calling so as to get information better, you can call him on the number on the screen so that whatever that is your query, you can ask him. God bless you. So, okay, you are welcome once again.
Thank you.
Now, can you tell us and tell my audience the current law on EU under the immigration rules?
Thank you very much. Good evening, audience. I'm very excited to be with you today. First of all, we have decided to talk about EU law today. And the reason being that it comes as a surprise that as UK is leaving the EU, so also a set of rights needs to be discussed. Now, as we are transitioning from being an EU country to a non-EU country, there are certain relationships that have been built over the years. We shouldn't forget that United Kingdom has been a member of the EU in the last 44 years, and that has possibly opened up different relationships, different rights, different situations. So it's important we today or tonight understand how these affect our lives and look at how we would possibly fare in the new UK without the EU, or as we stand now, we are still in the EU. Now, for the record, the United Kingdom is still part of the EU.
Okay.
The Article 50 kicks in next year, March 31st. So all sets of rights in the EU still remain intact. So people have a lot of anxiety about, Article 50 doesn't mean we're out of the EU.
Exactly.
Yes. Article 50 only is a notice that it's like when you're renting a property, you tell a landlord, you know what? That's my quick notice. So Article 50 in law means, in the EU treaty laws, means a notice that a particular country is leaving. So that's what UK has done. Okay. Until the UK exits on March 31st, then it comes into effect. But from now till then, all sets of rights in EU regulations and laws are still there. They're still intact.
Wonderful.
Now,
I'm sure a lot of people don't know this.
Yes.
Wow.
Having said that, I would say from a strategic point of view, it's not too late to make any EU applications. These applications take up to 6 months or less to decide according to EU regulations. So if UK technically will leave by March 31st, there is still an opportunity to make applications up to September, because September to March is 6 months. So if you have come across EU rights, or potentially, say for example, if one of your relatives comes from Germany to come and stay here, even today or tomorrow, then you know that you are still opportuned to get some rights under the EU. So the EU laws and rights are still there until UK would literally leave by March next year. And having said that, there are discussions to preserve some of these rights, but that's a political question. We are not politicians, but but that would unravel with time. That will unravel with time. Now, to begin, we look at the basic principles of EU law and rights. These rights come from the EU directives, coming from being a member of the European Union. Now, United Kingdom being a member, one of the 4 pillars of EU is movement of people. That is what affects people, rights, residencies, movement of people. So that's the core principle we're going to look at today. How can you be here and you have connection with the EU? How can you stay here? The basic one is you would be a family member. That's one of the categories of recognition of EU laws. Family members means spouse, children, and if they are over 21, they are dependents. Also, there are also those who...
Do you say if they are over 21?
They are still category... No, they are still family members.
Oh, right.
So being a family member is the highest level of rights in EU law. And the most common one is spouse, being a spouse. So being a spouse automatically makes you a family member. And also, if you have children, and also even though you have children and they are more than 21, and they depend on you, they come under the umbrella of being family members. Yes. Also, within that category, they also have people who are dependent parents and grandparents. It's very confusing how EU law sort of breaks down these relationships. You would expect siblings and brothers to be family members. But in the core EU laws, family members are dependent parents and grandparents. So
really?
Yes, they are family members. Most people don't know this, but parents and grandparents are family members. They occupy a very high hierarchy of rights because family members have very, very core rights in EU law as against extended family members. So there's another category which are extended. But today we focus on family members. Now, so this is simply how you obtain these rights. But in the context of how you get these rights, your sponsor or your EU family member must be working. That is one of the ways they become qualified people. So there must be a qualified person.
Certain amounts they need to be earning before they can make such an application for a family member.
Yes, there is no set amount of money, but there must be a reasonable expectation that money you can live on it without relying on
the government.
You can't say you earn £1 and you want and I mean I'm giving an example. So there must be reasonability in terms of how much you earn, but the core way of weighing it is how much can a family live on. But being employed is one of the ways, having a normal job. And then there is also self-employment. If you're self-employed, you are also a qualified person under EU law. Up to people who are self-sufficient. There are people who have reasonable amount of money and they may not be able to work, but they have money. They are classified as self-sufficient. So they are qualified persons also. And also if they are actively looking for work or they are students, they become qualified people. So they become a qualified person. So in the context of how you get these rights. So these are the basic fundamentals.
How about if they're studying?
Yes, students are also qualified persons. Yeah, they are qualified persons to some extent. They can be sponsors for applications. Yes, students, yes.
Wonderful. Now that brings me to the other question. I don't know if you need to throw more light on the rules.
Yes, we've talked about family members. There's another category which is, of course, the extended family members. These are like siblings, uncles, and other relatives. So that is where you get people who have, say, your uncle who is a German citizen he comes here to work, then you are what in EU law they call an extended family member. So basically, they can sponsor your application to stay here. But,
really?
but there are certain provisions, certain regulations you need to meet.
Okay.
So you become, under the law, an extended family member. But the law doesn't close the level of extent to which you can be an extended family member. But the core ones are cousins, nieces, nephews, brothers and sisters. So they are all extended family members. So you can become an extended family member of an EU national who is exercising treaty rights by employment, self-employment, or being self-sufficient. Okay. So that is where a lot of people find it's a much broader category of rights, because it does extend to quite a wide range of family relationships, nephews, uncles, grandparents. As long as they depend on you, they become your extended family members.
Okay.
And also,
you have to be able to prove that you can look after them, you can take
yes,
care of them.
The EU family sponsor must be working,
okay,
or must be engaged in an economic activity like being self-employed or having sufficient funds. So but that's the core. It applies to every situation, even spouses.
Okay.
So you must show that you are engaged in an economic activity. That's the core principle of EU, that you're not going to depend on the social assistance system of wherever you are working or you're living. And again, another interesting category of extended family members are unmarried partners.
Okay.
Unmarried partners are people who are in a relationship.
But they're not married.
They're not married. They're living in a relationship akin to marriage. It's not marriage. They're living together and they have a genuine relationship. They are called unmarried partners. Now, the most important provision relating to unmarried partners is that they must show a genuine relationship akin to marriage. There has been so many court decisions on what is what is the test for a genuine relationship. Sometimes the Home Office have tried to pin it down to living together for 2 years. And also, that is a guidance. In many cases, people would say, oh, I haven't lived for 2 years with my partner, so why would I be able to qualify? Because you need 2 years. But there are some case laws that have defined what being in a relationship akin to marriage is. They believe 2 years is a guidance, but they also look at the quality of the relationship. It could be less than 2 years, but the overall core important aspect is the quality of the relationship.
How do you define the quality of a relationship of unmarried partners? You know, like most people, when they are married, they belong to a particular organization from either the man's side. But when they are unmarried, most times they don't go through this process of being a member in the, you understand? Because you don't just take a girlfriend and to your village meeting as your wife. People will question it. How do you find a healthy and qualified unmarried partners?
There is no objective test of definition, but it is rather a subjective test, in the sense that every relationship is different, but the decision maker wants to see evidence of cohabitation, paper trails of cohabitation. Say, for example, utility bills, tenancy agreements, very strong evidence. Say, for example, if they're renting a room or a flat, both names are in the tenancy agreement. In the eye of the decision maker, that means there is cohabitation.
Okay.
Cohabitation is the test. And also if there's shared bank accounts or responsibilities, but they want to see bills in the same address.
In the same address.
In the same
of
address.
Both parties.
Of both parties. Sometimes jointly, sometimes separately.
Okay.
And also correspondence coming through. These are ways to subjectively look at people and say, you know what, from what I've seen on paper, they seem to be living in the same address, because cohabitation is the key. Are you cohabiting? EU law says you can get rights because you're married, but you have to show up some degree of genuineness and some degree of documentary evidence to prove that this relationship is genuine and you are cohabiting. So that makes you qualify under this provision of the law.
There was a time a friend of mine was telling me that when she went for the interview, one of the questions that she was asked was, do you know the color or what best food
Yes.
does your spouse, you understand, or your partner, what do you know as a, and when they ask the other partner, if they don't say the same thing, it means that you don't really know who your partner is, or what color of this does it wear, you know, that kind of a thing. So, and that's one of the things that they do as those times. I don't know if it's still what they do now, to ask somebody what's his best food,
Yes.
or what's his best color, and then they come to ask you. I mean, these questions are questions you don't expect that you'll be asked.
You've raised a good point. One of the core, one of the most important aspects of decision making in EU law is to test the relationship, whether it's genuine, because it's got to be genuine. For example, if it's marriage, it's got to be a substantive marriage. That means in law, the marriage is standing. We're going to go into other forms of marriage in proxy marriage when we talk about this. So the marriage has to be valid, and the marriage has to be genuine. Now, the decision maker they have a very broad range of powers to come to this decision-making process. And that's where you came in talking about a friend that was invited to an interview. So they have powers to invite to an interview. But that does not mean that people are very, not very comfortable attending interviews. Not everybody will do well in an interview.
Exactly.
But what I would say is that if you come across that kind of scenario, you do your best to give the decision maker the best picture of your relationship. That means prepare for the interview. That means go through things that you wouldn't normally as a couple put your mind to. Like people conduct their lives not thinking, you know what's the make of our TV? Because the decision maker needs information, and they come up with an interview with some prepared questions, which invariably they will draw conclusions from based on answers. So
that made serious sense.
Yes.
What's the make of your TV?
Yes.
If you all actually live together, you should you should. But sometimes you don't think that this question can come.
Yeah, these are the things
my God.
we take for granted. But if you have that situation where you've been invited to explain or an interview, you have to just prepare as much as you can, and also bring as much documentary evidence as you can, photographs, letters, because they draw questions from different dynamics of a typical relationship. So you need to, obviously they wouldn't be prying into privates, but the bottom line is that there must be a standard of knowledge of your relationship and how well you know each other, up to how you met, where you met, dates, birthdays, friends, and it's not an exam, but it's
go out to parties, take pictures with family members and all that. But relationships now, anyway, we'll come to that. Most people don't even, they keep whoever they dated, they keep them behind and then find girls outside to go out with.
Yes.
Anyway. So now that you've thrown a bit of light into, is there more thing you want to say before I go to the next question?
Back to the extended family members.
Okay.
I want to highlight the importance of being very, very strategic in how you approach applications under that category. Now, there's a technicality in the law that says that extended family members must show that if they depend on the EU family member, they must show that that dependency must have started from their country of origin. I'll give you a very simple scenario. If a Dutch citizen wants to sponsor his brother who is probably a Nigerian or a Ghanaian, you must show that there has been a history of dependency before your brother came to the United Kingdom. That means it's a two-pronged evidential burden. You show how you started, and you show how you are dependent now.
Somebody, sorry, before I cut you off, somebody just asked a question. Can you elaborate the Commonwealth position?
Well, with the Commonwealth, in terms of rights and laws, there is nothing that actually in the laws that say, okay, Commonwealth citizens have that or that in terms of rights. But because of, I guess the question may relate to what's going on with the Windrush. Is that so? With the Windrush, the reason why the word Commonwealth was used is because most people that had that situation came from Commonwealth countries. But the policy now on the ground is that Commonwealth citizens who have come here before 1973.
Before 1973?
Yes. There's a Home Office current policy now to kind of deal with the issue of Windrush, but the document did not end it with Windrush. It did extend to Commonwealth citizens. So that's where we have to look at how that dynamics affects people who are not typically Windrush. Now, Commonwealth countries, we know that Commonwealth countries are countries in Asia and Africa, so there wasn't Windrush connected to this continent. So, but if the new policy says Commonwealth, and you know someone or you have been here before 1973, then there's an opportunity there to make contact with the Home Office or seek legal advice to see.
So if you have been here before 1973
as a Commonwealth citizen,
this is an opportunity for you to actually seek an advice.
Yes.
Right?
Yes.
You may be qualified.
Yes. Or you know someone who you think they might have come here that period. That's from before 1973. You could, there's a Home Office hotline looking after that kind of scenario, but you could seek advice. So Commonwealth, in the context of the new policy, covers quite a wide range of countries, but the key is the date which the individual arrived in the United Kingdom.
I think this is very important because most of us, when we come, we don't keep dates or you don't keep documents. What happens at the particular time you arrived in the UK should be kept, because that might help whenever you want to make an application, just like this Commonwealth rule now.
Yes.
You know, that if you are here before 1973 is an opportunity for you. All right, sir. Sorry for cutting you off. It's just someone asked that question, so I had to put it across.
Yes.
All right.
So going back to the extended family members. Now, we talked about how you need to show that you were depending on your EU family member before you came to the United Kingdom.
All right.
So that is a very important aspect of the requirement, which is easy to overlook. So the Home Office will look at a prior dependency and a present dependency. So you depend now, fine, but you must show that you were dependent before coming to the United Kingdom.
And this could be like sending money across.
Exactly.
You have a receipt.
Fantastic.
And there's a bank statement that shows that you've been receiving money
Correct.
from this particular
Yes.
family member.
Correct. Absolutely.
As an extended family.
Yes.
Okay.
That is another aspect of it. Also, if you're simply a member of household, which is easier to prove. Some people have lived with their family members before coming here. You know, so people sort of have lived in the same house. The law says you could be a member of household or dependent. They run, it's an alternative.
What's the difference? That's so funny.
You see,
being a member of household
or a dependent.
A dependent.
Yeah, you choose which one you can prove.
Oh my God.
You choose.
So what's the difference?
In terms of difference, I believe, I may be wrong, and it is my view that being a member of household is easier to prove.
Yeah.
Being a member of household, look at it practically. If you live with your uncle, an EU family member, and you have your name on the TV license, right? And he has his name on the on the gas bill. So if you look at those
Same address.
same address, then it shows that you're a member of that household straight away.
So,
But
and the other one?
the other one is dependency. Dependency means you must show the decision maker that you are
dependent on that person
financially,
but you don't live. It doesn't necessarily mean
yes,
that you're living with the
yes,
person.
that means you can be dependent on someone, but you don't live with that person. You see, so you could be in Manchester and your uncle is working in London,
transferring, paying your house rent,
correct,
and
giving you pocket money
from his account.
Yes,
he's transferring money,
yes,
on your behalf,
yes,
to pay for your house rent,
yes,
and your well-being, and
yes,
shopping for you,
yes,
and all that. Okay,
yes, that is proof that you're dependent on him.
Okay,
that is, if you can show that, fine. Then there are those who just live
without nothing,
who live with their family member. They don't have to, because when you live with your family member, technically you are depending on them, because they pay the house rent, they pay the bills because you're not working, and they give you pocket money. If you can't find
any proof,
then there's a bill coming into the house showing that you live there. It's a lower standard of proof for you.
How about registration, like during voters'
yes,
registration card?
Anything that shows your name on the address, and also shows the name of your sponsor on that address. If you look at these two documents, you simply have technically shown that you're a member of that household. But if you can further show that you are a dependent, fine. So there is an alternative standard of proof, or way of proving as an extended family member under EU law. EU law is that gives you that choice to come under the umbrella of being a member of household, or simply showing that you depend
on the person.
So it's a choice of what level of proof you have and how your situation sort of, matches the provision of the law. So that's and we shouldn't also forget the most important thing: you must prove how you're related to them. I'll give you an example. If it's your uncle, you need to show series of birth certificates connecting the two of you. Say, for example, if your mom and your sponsor are brothers, you must show your mom's birth certificate.
Oh, really?
Because your mom's birth certificate will show that your uncle and your mom have the same parents. And then you should...
Those days, do our mothers have birth certificates?
Well, it depends on...
the hospital. Some hospitals don't even...
Yeah, it depends on country, but there are alternatives. And where you cannot find birth certificates, you can use DNA to prove that there's a relationship.
Yeah.
There's an alternative.
That's okay.
Yes.
That's good. I hope a lot of people now, it's your time to start doing something, because so many people, the moment that EU thing that is it UK is out of EU, so they feel there's no hope anymore for them, and some people just relaxed. They didn't make any application, or they haven't made any application. So according to Mr. Ohanugo, you can see now that there is opportunity for you to do something right now. You're not late. You have to start making an application or seek an advice. Speak to your solicitor, or better still, there is a number on the screen that you can call for an advice. All right, so do we go to the next question then?
Yes.
So that, I think the next question is, how can an EU divorced spouse, I've been waiting for this question seriously, because I've got quite a lot of friends that are going through this now, and they don't know what to do. So how can an EU divorced spouse stay here after the divorce?
Yes. Now, that is governed by, there is a provision on the law, EU regulations, that says that if you have being a spouse of an EU national, subject to certain requirements, you can stay here. What the law says that you have retained these rights. So you don't lose them because of the breakdown of the relationship or because of the marriage, divorce in the marriage. So technically, you must show that you've retained them. You don't. These are the rights that life circumstances will not take away from you. So we call them retained rights. You retain them by fact of law, by fact of showing that one of the basic requirements is that the marriage must have lasted for.
I was going to
Yes.
ask that
Yes.
for how long, because some people just get married
Yes.
and after a few months
Yes.
the marriage breaks down. So
Yes.
what happens?
Well, if it's a few months breakdown, the law requires in EU provisions to have been married for 3 years before you can retain the rights.
Okay.
If the marriage breaks down before the 3 years, then probably there could be other factors that could help you make an application. But the core way you retain rights after a divorce proceeding is that the marriage must have lasted for 3 years.
Okay. How about if the marriage has not lasted for that 3 years, assuming they were married for 1 year, and then there's domestic violence?
Yes.
What happens?
That domestic violence is an entirely open provision for everybody, whether you're in EU law, whether you are unlawful, or whether you come under the immigration rules. Domestic violence is everybody's right. The right to protect people from harm. So if you have that situation, then there's a provision in the immigration rules that can let you stay here as a victim of domestic violence.
Okay. How about less than 3 years? The marriage is less than 3 years. Someone is asking, and there is a child involved within those period, but it's less than 3 years. What happens?
When a child is involved, and you can also retain it in that situation. If the child is in school and you're the primary carer of the child.
The child.
Most cases, when you have a relationship with an EU or you're married to an EU, technically that EU child, so that child in the relationship may have an EU nationality.
Okay.
So you become a parent or a primary carer of
the child, an EU.
Yes, an EU child. So you fall from spouse and you become
a
carer. So if anything happens to that marriage, for example, and you're the sole carer or a primary carer, so there is a provision
for you.
Yes.
I hope you're listening.
It's the famous Zambrano or Chen. Well, we don't want to be too. Yes. So Chen is the case law about people who can be primary carers of an EU child. So if you're caring for an EU child, say for example, even if that child did not arise from a normal marriage relationship, if it's, say for example, you had a relationship and a child comes out of that relationship.
Okay, even when they are not married.
Yes, yes.
But during courtship.
Yes.
A child comes.
Yes, an EU child.
An EU child.
Yes, you become. If you are caring for that child, you become a primary carer of an EU child. So there are sets of provisions in the EU regulations that gives you rights. You can make an application as a primary carer of an EU child. So that is the law, yes.
Wow. So in a situation that you are married to an EU person,
yes,
and you've lived together for 5 years, and your spouse, or for 4 years, I say, then your spouse disappears.
Yes.
Because I remembered a lady that I know. She had a child out of that relationship, and she came under the EU spouse, the application she made, and they gave her about, I think, 5 years. And with it, before that 5 years, the man disappeared, and he was nowhere to be found. He was actually somewhere, but he wasn't making contact. And when the lady was to renew her stay with her daughter, they said she must provide the man.
Yes, that is not unusual, because each time you are making any application under EU law, your husband or your spouse is your sponsor. You can't get rights under EU law without somebody sponsoring you. So that's why the decision maker or the Home Office requires their documents. They do require their passport, and you can't find them, which is very, very difficult. And the truth is that the law requires a sponsor to gain rights, because EU rights are rights that basically they are fast changing rights. You must show that you meet the provision at each point in time. Say, for example, if you lose your EU residence card, you must show that you qualify as at the date of reapplying. So if the Home Office wants the document of that person that's no longer available, they are trying to establish, is there an EU relationship there? Because they must grant rights based on EU law. The basis of the grant of that residence application is based on an EU law. The EU partner must show, the applicant must show that there's an EU sponsor. Without that, it kind of falls apart. But that doesn't mean that if a child is involved, then it can move to
From
Section
that.
55, which is interest of children. So there will be other provisions in the law where the decision maker will look at the best interest of the child and look at the overall, they look at the whole case in the round. The EU father is not available, they can't get hold of his passport, but there are other rights under Article 8, under Section 55. They can look at the best interest of the child and say, you know what, if we remove the mother,
what happens?
who will look after this child? So it falls under.
And if you remove the child has been comfortable, made friends, and all that. All right, okay.
So there are other.
So you can shift from
EU to Article 8 and also stay around Section 55. There are other provisions of the law, because at the end of the day,
for those of them that there is no child involved, and they've lived for 5 years or 4 years, and this guy disappears, I go beg on her, make her no let them disappear. If the marriage, because most men, when they know you depend on them to get your whatever, they begin to maltreat you. Be patient. I know it's not easy. If not only that one go make you stay, make you just be patient until you collect your thing. If you collect and finish, you won't disappear, make it disappear. Anyway, that's my own advice. Sorry. All right. So, yeah, can you throw more light? Is there anything you need to still add to this?
Yes. On the issue of your question about
the divorce.
There is also a huge technicality in the law when you're divorced. Now, you show the marriage lasted 3 years. That means you couldn't have started your divorce proceedings 3 years before. So you must be 3 years in the marriage. Then you commence divorce proceedings. That's when the date starts to count. When you commence divorce proceedings. That's one important aspect. Second requirement is that the parties must have lived here for 1 year, United Kingdom. So cases where you are married and your spouse disappears to another country, you must show 1 year that you people have lived here for 1 year, both parties. That is another important provision of the law. Then the most important one that actually is a minefield is to show that the former EU spouse is exercising treaty rights as at the date of divorce. That is the
Sorry, can you repeat that?
That the former spouse, the former spouse is exercising treaty rights as at the date of divorce. That is the most important provision. So it's not enough to say, oh, that's my divorce decree, absolute. We've lived here for more than a year. You must show that as at that day, if the divorce took place on the 24th of March, you must show the decision maker that at that date, your former EU spouse was working in the UK. Yes. You must show that. A lot of people struggle with that, but that is what the law, because there's many litigation around that, showing that your spouse, your former spouse, and people are wondering, we are divorced. Why must I show? How can I show that he is still working in the UK? We're no longer in touch.
Exactly.
So there's a difficulty there. But the underlying principle is that you are still trying to claim rights under EU law. And to claim rights under EU law, your sponsor must be engaged in an economic activity. So as at the date of divorce, you must show that
He was still
working or self-employed or self-sufficient, but you must show one of the categories of how they qualify under EU law as engaging in economic activity. That's the most difficult provision.
What I'm going to add to what you've just said now, you see, actually people separate or divorce, and when they divorce, they become enemies. It doesn't necessarily mean that when you're divorced, you don't need to talk to each other, or when you see each other, you're enemies. Imagine you fall into this category and you needed to prove that your spouse or your sponsor is still working somewhere. So that means you need to still keep in touch. Despite that you've divorced, you can't live together. It's not compulsory that you must live till death do you part. Like, that's the oath you take. But if it's not working out, it's not working out. And when you're separated or you're divorced, try to be friends in case you fall into this and you need that his documents to show that he's working or he's somewhere. So this is just my own advice to those people who are divorced and they see themselves as enemies. Please change today. So are we going to go to the next? I was going to ask you one. How about an EU spouse who lived together for 1 year and then the sponsor dies?
Yes. Oh, that's there's a provision you can retain rights if the EU sponsor has lived there for 1 year and there's an unfortunate circumstance of death. Yes, you can retain that right.
You can retain that right.
Yes, 1 year. Right. You need to show that
within that 1 year.
Yes, that prior on the date 1 year before the event of death that they were here. That you need to show that that's sufficient to, and also the death certificate that they're no longer. Yes, because look at it from the point of view, if your sponsor by unfortunate circumstances passes away, the law does not want to deny you of your rights because of that unfortunate circumstance. So they have a protection in the law. Yes.
Now, I'm going to ask you, this is a sweet question and I love it. I've been waiting to ask this question to help those of us out there who may fall into this category, because it's very common out there. What is the current position of the law with EU rights and proxy marriages? Proxy marriages. And now I want you to explain what proxy marriage means.
Well, proxy literally means in absentia. That's
in absentia.
Like if you want to vote by proxy, there's an election coming now, and people can vote by proxy. That means they are not present.
Okay.
So they can vote. So marriage by proxy means...
Not in Nigeria. You know, they don't give us the opportunity.
Okay. Marriage by proxy is that marriage entered into where the parties are not available. That's the simple definition of proxy marriage.
Okay.
Say, for example, and the most interesting part of this is that my understanding of proxy marriage is embedded so much in African culture. Your parents actually can go and marry on your behalf.
On your behalf. It's very common.
It's very common.
Mostly in Igbo land, where I come from.
Yes.
I remembered a man those days. Okay, let me say, I know the history when somebody was put to bed, just gave birth. And actually, before that child was born, another family had been waiting that their son is going to marry that unborn baby if that baby is a girl, because their child is a male child.
Yes.
And do you know that a coin was dropped in a pot that they have married that child that was just born?
Yes.
and this child grew up, and yet they married. They now performed the marriage rites,
Yes.
even when these kids were little.
Oh, I see.
So,
Now, that's simply proxy marriage is. We've understood what it is, but there has been a lot of controversy legally on proxy marriage under EU law. Now, the reason why people engage in proxy marriage is personal, and I have come across people who are lawful in this country, and they have opted for proxy customary marriage,
okay,
and have their the wedding
the
here.
white wedding
Here.
here,
You see,
but the customary
Yes,
marriage
takes place.
was done
Yes.
in Africa.
Yes, I've had, and that is actually how most people conduct their marriage. They don't want to, because you're going to travel twice, and then you have to come back. So expenses, convenience, and a lot of
Exactly.
things can make someone engage in proxy marriage without no intention to engage in proxy marriage. And the truth is that the customary laws of, I will give you an example, Nigeria, sort of have provisions accepting accepting proxy marriage as valid. Now, what has happened is that over the years, it has come to focus because of immigration, and most people, in all honesty, being in a marriage situation, genuine marriage, because they are some people are afraid that if they travel,
They may not.
they may not come back. It's a genuine fear that if you
Yeah.
say to them, you can make an clearance application. But where proxy marriage is very, very well known is in EU law, because we're talking about EU law today,
EU
because
law.
EU law sort of does not look at status if you want to claim EU rights. So you may be unlawful by unfortunate circumstances, get married, and you would still get rights under EU law. So proxy marriage has become so dynamic in EU law, and over the years, it has become the focus of so many arguments and controversies. What is proxy marriage? Proxy marriage is, we've defined it, but EU law did not exclude proxy marriage. The directives, or it didn't define the directive where EU regulations were made and brought into UK law, did not exclude that form of marriage.
Wow.
Proxy marriage. It didn't exclude it, but what has happened that over the years, the Home Office have argued and have been proven wrong.
Wow.
The Home Office have over the years argued that if you engage in proxy marriage with an EU national, that marriage must be valid in the country of that EU national
that-
and also your own country.
Really?
So you must, what the Home Office have been arguing is that you must show, I'll give you an example. If you're a German, you're married to a Ghanaian, right? You must show the Home Office that when you've
done a
proxy marriage in Ghana,
in Ghana.
you must
and
show
then
that
in
German law, you must show the Home Office that German law recognizes proxy marriage and recognizes that marriage.
really?
That has been their argument. And they have been very successful over the years until last year. So you can imagine how many years of people that have been subject to this provision,
Wow.
and it took so many years of litigation for the Court of Appeal last year, May, to say that that line of argument is wrong. You cannot do that.
For real?
Yes. The case of Awuku versus Secretary of State and Home Department, Albert Awuku's case. Albert Awuku is a Ghanaian. He got married under customary law, and he fought the courts over the years. And the Home Office have this case law of Karim. Karim is a Nigerian case. So they've succeeded with case law of Karim. Karim says, the court says in Karim, look, if you marry a French national and you're from Ivory Coast, you must show that French law recognizes that proxy marriage. So as soon as you make an application under proxy marriage, the Home Office will say, you know what? The case law of Karim shows that French law recognizes that that proxy marriage, and that case, your case finishes there. So if
Really?
you meet them in court, you meet Home Office lawyers in court. As soon as they arrive, you say to them, what powers have you over this? There's a case law of Karim, and they will dismiss
that's
that.
it.
That's it. What's your power to say that this marriage, French law must show that this marriage is valid? Case law of Karim. And that's the end of the case. Karim was a huge legal weapon to say that. And you think about it, why would the laws of your country recognize that your marriage is valid? It doesn't happen in the conventional marriage situations where you marry in a registry. If you marry a French national in a registry in Lewisham, nobody will ask you that, did French law recognize that marriage?
Exactly.
Why did they discriminate for proxy marriage?
Oh dear.
So that has been the position of the law until the Court of Appeal said, no, this is not right. They won all the cases to upper tribunal, and only last year, the Court of Appeal in the case of Albert Awuku versus the Secretary of State. So the position now is that proxy marriages can only be valid if the law of where that proxy marriage was entered into says it's valid. They have the final say on validity, not the.
It mustn't be the two sides.
It mustn't be the laws of where you come, where your partner comes from. No. If you engage in proxy marriage in Ondo State, and the customary law of Akure says this marriage is valid, and the registrar signs it, and registers it properly and say, look, I, the registrar in Akure customary court under the Marriage Act and under our customary laws, this marriage is valid. That's final. And that is the position of proxy marriages, and that is where we are with proxy marriages. The Home Office have accepted it. Well, it's a court of appeal. I don't know if they are going to appeal, but as of today, that is the position of the law with proxy marriages. The marriage must, as long as it's valid,
where you
come from, if your customary law says this marriage is valid, they have the final say on validity. So that.
Obviously, we're going to go on a very short break. And then when we come back, we'll continue on this because this is so sweet. I love this topic. And I know a lot of people out there are stuck because of this same issue of the finance, how to pay ticket fare for the two parties, and then fly down the expenses.
And some people have 2 children.
Some people have 2 or 3 children.
You have to
oh my God. Then what do? You need to pay someone to look after the kids and then travel and all that. And they're stopped. But look at this law now. It's something that will benefit you. God help us. We're going to go on short break and don't go away. We'll come back. This is Princess Ifem Show on Heritage TV. God bless you.
The Nigerian Diaspora Direct Investment Summit, NDDIS, presents the first Nigerian Communications and Technology Summit in London. Working in partnership with the Federal Ministry of Communications, the Office of the Senior Special Advisor to the President on Diaspora and Foreign Affairs, the Nigerian High Commission in London, British African Business Alliance, we are attracting investors into the Nigerian economy. Our focus is on ICT on education, agriculture, health and business sectors. The summit will be attended by the Honourable Minister of Communications, State Governors, Director Generals of Agencies, UK Prime Minister's Advisor on Trade, private companies, individuals and diaspora business leaders and other international investors and funders. Come and meet potential investors, funders or partners. Date 10th and 11th May 2018. Venue Central London. To register, please visit www.nddis.co.uk. Heritage Television. Promoting African culture and heritage at its best. From talk shows that concern you to both local and international news that relates to you. From grassroots football to African children's programs. Heritage Television. We cover your social and special events like weddings, birthdays, church anniversaries and so on, and broadcast them live on our apps and online. Heritage Television, broadcasting everything about culture and heritage.
Heritage Television. We've got it covered. Do download our apps on both Android, iOS, and Windows mobile platform. Heritage Television, your very own TV station.
Hello, my people. Welcome back to Princess Ifem show on Heritage TV. God bless you. Today, like I said earlier on, if you started with us during this show, you will understand that today's show is very, very, very important to our lives. We may have brothers and sisters all over who are really in need to hear this, because some of us, when we are in a situation or in a state that we don't really know what to do, we don't know who to go to, we're afraid of making people aware of our situation, and you listen to a program like this where a solicitor is actually telling you and giving you information that will benefit you, like something like this proxy marriage. Imagine that you're here stuck with 2, 3, 4 children, and you are still to legalize your status, and you're confused, you don't know what to do. You needed to travel to go and make perform the marriage rite. How many people will you take with you? Pay the ticket fare? How much are you earning to do that? But this law, according to Mr. Ohanugo here, has, in fact, is a law that favors you. You can travel, you can send money back home, mostly in Africa, and ask people to represent you and perform the marriage rite. According to you, that is the proxy marriage. That's what it means. Please, can you just round up, because we've got just 3 minutes to go, about this proxy marriage? And
yes, the current position is the law courts have said that the marriage by proxy, if it's valid in your country, that means your laws recognize it as valid. Okay. That's the final. Your laws or your customary law has the final answer on the issue of validity. That is what the current case law is on validity of proxy marriages. If your customary law says that people can be represented in marriage and the parties do not need to be there, and that customary law of your place registers that marriage in the customary law registry, that is a finality on the validity of that marriage.
All right. Just one last question. Does proxy marriage affect or in favor of a UK national?
There is absolutely no. You see, when it comes to marriage, the rules have not excluded or included any form of marriage. Okay. There's no inclusion or exclusion. But as it relates to those who are getting married to British nationals, don't forget that the test of genuineness in EU law and the test of genuineness in immigration rules are totally different. Okay. So you might be very, very cautious in choosing a form of marriage. Okay. It depends on your circumstances. EU, we are talking the context of EU law. EU law. EU law requires a marriage. Requires your spouse or your sponsor to be working. All right. My time is up, unfortunately. We are going to be talking about this. We're continuing for next week. So same time, same day, Sunday. Don't go away. And it's Princess Ifem show. We will come back again to give you more light about immigration law. God bless you. Ndi banyi dalukwa no ekenekwa muno. Obu Princess Ifem show. Kaine wetaru no program aina bo the EU law. Uzu kana bia ai ga no kwa eba iji kwuo kwa ihe gbasara ka mmadu ga-esi wee no onodu wee no sie ike n'obodo Igbo ndewo no. Biko ka ikene ndị na-ege anyị ntị. And we greet you. We thank you so much for listening. Next week we're going to be here again talking about other areas of the law. Thank you so much for tuning in. Thank you so much.
God bless you.
God
Bye.
bless you. Thank you. Bye.
The Nigerian Diaspora Direct Investment Summit, NDDIS, presents the first Nigerian Communications and Technology Summit in London. Working in partnership with the Federal Ministry of Communications, the Office of the Senior Special Advisor to the President on Diaspora and Foreign Affairs, the Nigerian High Commission in London, British African Business Alliance, we are attracting investors into the Nigerian economy. Our focus is on ICT on education, agriculture, health and business sectors. The summit will be attended by the Honourable Minister of Communications, State Governors, Director Generals of agencies, UK Prime Minister's Advisor on Trade, private companies, individuals and diaspora business leaders and other international investors and funders. Come and meet potential investors, funders or partners. Date 10th and 11th May 2018. Venue Central London. To register, please visit www.nddis.co.uk.